As these are being handed out, Mickey will go through this House bill and explain it and answer questions. If you want to ask questions throughout the process, or like you said, write them down, that's fine. But the idea here is to make sure we have a great understanding of this House bill and how it affects the state of Michigan.
Yeah, I've got a feeling we're going to have a lot of questions, but we'll just let him go ahead and do his speaking first, and then we can go on in.
If you don't mind, what I intend to do is go through this bill
You'll need to.
line by line, so that if you have a question, it might be more appropriate to ask at that time rather than coming back. It may be far easier to respond.
Sure.
Because oftentimes one line is connected to the next, and it may be far easier to understand if the question is asked then. I need to do that.
And take one and pass one.
Thank you. My name is Mickey Knight with Knight Consulting. It's a pleasure to be here. What I would like to do is to put the work side of those work sessions into this bill. There's been a lot of confusion, I think, in terms of what the bill is able to do or not do, what the authority might be able to do or not do. So the best way to alleviate any of those misconceptions is to go through line by line so that you know exactly what it does. House Bill 5651 was in response to, I think, some of the things that had transpired with the advisory Port Authority folks. This bill is an amendment to an existing law. The existing law was created in 1978 for the purpose of having Wayne County, Detroit have a Port Authority. So as you're looking at the bill, you'll see two different kinds of print. The small print is what is an existing law. The bold print is what would be the amendment to the law, which would be House Bill 5651. So again, the small print is existing law, and the bold print is what would be making changes to that law. We also have with us today John Loftus from Wayne County Detroit Port Authority, and he is a foremost expert on the operation of that port and has been around for some time. And those questions which might involve the Detroit Port Authority, if you don't mind, I would defer to Mr. Loftus. House Bill 5651 passed 98-9. This would allow the County of Muskegon or the City of Muskegon, or in combination, the city and the county, to form a port authority. Previous to this amendment, there were only two ways that you could be a port authority. One is to be the Detroit-Wayne Port Authority. The second would be to be the Port of Monroe. They're organized under a totally different mechanism. It's called the River and Harbor Acts of 24th February 1835. Their port authority has been around since July of 1930. So that law applies strictly, or that particular ordinance applies strictly to Monroe. So we couldn't qualify to be a port authority through that authorization. So we are working to make this amendment. If you would please, on page 1, it indicates that this is, yes, sir.
I have a question right out of the gate. One of the things that's come up, one of the questions that's come up with this language is what would stop, say, the city of Grand Rapids in establishing a port here in Muskegon? Because it simply says a city or county.
Well, as we go through this, I think you will see that, one, they don't have any facilities on the water, so they would have to form a combination with a city here or a county.
Okay.
John,
The legislation is fairly clear. The existing law is within your jurisdiction. Grand Rapids has no jurisdiction within your area. Now, you could do a multi-county, multi-city, even in the existing law. Muskegon wanted to join together with Kent County and doing, you could do that. You could do that right now. So it really is up to you on how you set it up.
Got it.
Okay?
Going down the first page, starting with people of the state of Michigan enact, and again, this is an amendment to the Hertel Law, Thaddeus Stopchinski Port Authority Act. Authority means a port authority created under this act and may also include the area within the jurisdiction of an authority. Constituent unit means a city or county requesting incorporation of an authority. Governing body of the city means the city council or city commission of a city requesting incorporation of authority created under this act. Governing body of the county means the county board of commissioners of a county participating in an authority created under this act. Port facilities means those facilities that include, but are not limited to, seawall jetties, piers, wharves, docks, boat landings, marinas, warehouses, storehouses, elevators, grain bins, cold storage plants, terminal icing plants, bunkers, oil tanks, ferries, canals, locks, bridges, tunnels, seaways, conveyors, modern appliances for the economical handling and storage and transportation of freight and handling of passenger traffic, transfer and terminal facilities required for the efficient operation and development of ports and harbors, other harbor improvements or improvements, enlargements, remodeling, or extensions of any of these buildings or structures and other real or personal property necessary to enhance commercial or recreational maritime activities. Project means the acquisition, purchase, construction, reconstruction, rehabilitation, remodeling, improvement, enlargement, repair, condemnation, maintenance, or operation of port facilities, public infrastructure, and other real and personal property necessary to achieve the purpose of this act. What I would like to point out before anyone asks the question, this Port Authority does not have the authority to condemn property. The condemnation that's mentioned here applies to the Port Authority of Wayne and Detroit, who do have that authority. So we would not have, and it's specifically prohibited later in the Act. A city and county, a combination of counties, or a combination consisting of at least one city and one county by joint resolution of their respective governing bodies may request the governor to authorize the incorporation of an authority. Beginning January 1, 2016, a city or county, by a resolution of the governing body of the city, the governing body of the county, may request the governor to authorize the incorporation of an authority. The governor shall consider the recommendation of the State Transportation Department. So essentially, if you're interested in having a port authority, you would have to make application to the governor and go through the Department of Transportation. So both would have to approve your application. In authorizing the authority, the initial articles of incorporation shall be approved by the governor and may thereafter be amended by resolution of the authority, subject to the approval of the governor. After approval by the governor, the articles of incorporation and any amendments to those articles shall be effective upon filing with the Secretary of State. An authority created under this act shall be a body, corporate, and politic. Essentially what that means is that they're able to borrow, lend, pay debts, and operate as a corporate and a political body. The exercise by an authority of the powers conferred by this act shall be considered and held to be an essential government function and a benefit to and a legitimate public purpose of the state, the authority, and the constituent units. Section 5. Except as provided in Section 5, an authority shall consist of 5 or 7 members, as follows. And again, this applies, as you can see, this is small print. This applies to the Port of Detroit. Does not apply to anyone that would be incorporating or having a port authority under our portion of the Act. 1 member shall be appointed by the governor, except as otherwise provided in the subdivision. The remaining members shall be appointed by the governing body of each city and the governing body of each county that requests the incorporation of the authority. Representation on the number of members of the authority shall be determined by agreement among the incorporating units and included within the joint resolution requesting incorporation of the authority.
I have a question on that.
Yes.
It doesn't seem like you should have just the people from the city or the county on that board. In our situation at least, we have private owners of some of the docks. It seems like they should have a seat on that board.
Yes, as you get into this, what was being read was how the authority members are appointed for Wayne County, Detroit.
Okay.
As we get a little bit further, the county, if the county is the one making the request or passing the resolution requesting to develop a port authority, then you would be the ones that would determine who would be sitting on your board. However, that would be a part of the articles of incorporation, which would have to be approved by the governor's office and by the Department of Transportation. So there would be a fair amount of leeway in terms of who, if you're the ones that are doing this, who you would be able to appoint.
Okay.
That would have to be included in your articles of incorporation.
But it already says here how many people can be on there.
That is for, that's
That's just Detroit.
Detroit.
But
yes.
that is going to be part of the bill too, correct?
Well, it will be part of, it will stay in the bill, but that only applies for the city of Detroit, or for the Port Authority of Detroit. As we get a little further here, you'll see that, and it outlines,
Okay,
how their makeup is done.
okay.
And all of the small print that you see really applies as it relates to membership to Detroit.
So what we're saying here is that this bill here is really a statewide bill.
Right.
It's for the whole
Absolutely.
state of Michigan.
Yes.
It's not for Muskegon, it's for the state.
For the whole state.
But when Muskegon applies, if it decides to apply for a port authority, then Muskegon and their partners and whoever, private, public, have the ability to put together the team and the bylaws and things that they're gonna send into the governor to have approved.
Yes.
Without this new bill, Muskegon could not create an authority.
No.
It just belonged to Detroit.
No.
Yes, they could.
That's
You could do
right.
that right now.
What's that, excuse me?
You could set up a port authority right now if you
Oh,
want.
within the county, you could, yes. But it would not be as readily accessible for grants and that sort of thing. John, go ahead.
Now, you could set up a port authority right now, a city-county port authority today. And it could do all the things that are in the existing, you could go after grants. The problem with the existing law is right at the outset where it says that, where it defines a port facility. Where by defining a port facility as a facility in current language says owned by a port authority. That is the number one issue that you have to pay attention to. That was what was the biggest concern as this legislation was being developed, because private owners did not want to turn their property over to a port authority to benefit from the activities of that port authority. And I agree with them 100%. That was a flaw in the legislation in 1978 when it was passed. Why they did it, I don't know. But it's time to change that. So a government agency can actually assist anybody. And in a port like Detroit, where I've got 25 terminals, only 2 of which are owned by the Port Authority, that restricts us from helping people like U.S. Steel, AK Steel, Marathon Petroleum, Lafarge, St. Mary's Cement. There's all these great operators I can't help because I don't own them. But if you create the Port Authority, you can go after grants. You can do all those things. And that's the benefit of having that Port Authority.
The major distinction would be that you would be able to provide assistance for private property.
I see, thank you.
Skipping through, if you don't mind, because I know this is getting a little tedious, we'll skip through all of the means of appointing as it relates to the city of Detroit and the Wayne County Port Authority. The next bold print to the extent not protected by the immunity conferred by 1964 PA MCL 691-1401-2, and this simply is because the Immunity Act has been expanded, and this would include that as well.
What page, what number?
It's page 5. Line 11. Line 16, moving on down. An authority may adopt, amend, repeal bylaws for the regulation of its affairs and conduct of its business, sue and be sued on the same basis as the state, and adopt and register with the Secretary of State an official seal, alter that seal at its pleasure. Maintain offices at a place or places either within or without its jurisdiction as it may determine. Acquire, construct, reconstruct, rehabilitate, improve, maintain, lease, as lessor or as lessee, repair and operate port facilities and other property it may acquire or hold within its territorial jurisdiction, including but not limited to. And it goes through a whole list, as you can see, of things that they're able to do in terms of
That already exists.
that already exist, yes.
Okay.
Going to the bottom of page 6, number 26, and this is a key reason to have a port authority as opposed to having the county do it by themselves, is that you can enter into public-private partnerships with other owners of property, port facilities within the jurisdiction of the authority. Now, this is another key point. Nothing in this act shall limit the property rights of any person that owns property or port facilities within the jurisdiction of the authority. So the Port Authority would not be limiting any of the property rights of any of the private operators as they presently operate. The powers granted under this act are in addition to those powers granted by charter or other statute. So it doesn't limit, this act does not limit the county from its normal actions. The next, if you would, A, line 8, appear in its own behalf before boards, commissions, departments, or other agencies of the federal government, or of any state or international conferences, and before committees of the Congress, the United States, and the state legislature, in all matters related to the design, establishment, construction, extension, operation, improvement, repair, or maintenance of a project operated, maintained, financed, or supported by the authority under this act, and appear before any federal, state agencies in matters relating to the transportation rates, port services and charges, demurrage, switching, wharfage, towage, pilotage, differentials, discrimination, labor relations, trade practices, river and harbor improvements, aids to navigation, permits for structures in navigable waters, all other matters affecting the physical development of and business interest of Port Authority and those it serves. Starting on line 23, this is a very important distinction too. May make application for, receive, and accept from any federal, state, municipal agency, foundation, public or private agency, or individual, a grant or loan for or in aid of planning, construction, operation, or financing of a project, and receive and accept contributions from any source of money. And again, you would be able to have a private-public partnership and be able to use those resources on a private piece of property. The rest, you will notice there's a highlighted executive officer on line 5. That simply is making the name consistent with the present way of referring to folks who are the chief administrative officer. Moving on down to line 17. An authority may, subject to the authority of the federal government and the state with the agreement of the constituent units. Constituent units would be those that had requested through the governor and through the Department of Transportation, made the request to be a port authority. So a constituent unit, if you made the application, you would be the constituent unit. If you were a partner with the city, it would be both you and the city would be the constituent units.
And riparian rights owners was what was added, right?
Yes, that was added, and the reason being is that we wanted to take into consideration those owners of property They have riparian rights so that their rights aren't violated and they can be consulted. And we guarantee they would be consulted before anything that would be done either on their property or within their riparian right. If we would, going on to section 12, line 23, an authority may acquire by purchase or lease when it considers the purchase or lease expedient, lands, structures, property rights, rights-of-way, franchises, easements, and other interests in land, as it considers necessary for the convenient, for the construction or operation of the project, on terms and at a price as considered reasonable, agreed upon between the authority and the owner of that property. Except as otherwise provided in this subsection, in subsection 4, an authority may be subject to the Uniform Condemnation Procedures Act 1980, PA 87, MCL 213.51, and as you can read there. However, as you go deeper into this bill, any unit or any port authority that's created and goes into operation after January does not have condemnation rights. They are not able to condemn. It doesn't change the county's ability or the city's ability to condemn property for the operation. But the Port Authority will not have their own right of condemnation of property. So if they want to condemn a piece of property and incorporate it into the Port Authority, it would be done through the county or through, if the city is one of the constituents unit, through the city. Again, they do not have the right to condemn property.
That already exists. The county can condemn property.
Yes, yes, this does not create a new condemnation procedure. It's one that already exists within the county and within the city. And it specifically, if you skip down to line 23, Port Authority established on or after January 1, 2016 shall not condemn property under this act. It's very specific. On 25, an authority and one or more constituent units may enter into a contract or contracts for the acquisition, improvement, enlargement, or extension of port facilities and for the payment of the cost of those improvements by the contracting constituent units with interest over a period of not more than 40 years. Each contracting constituent unit shall pledge its full faith and credit for the payment of its obligations under the contract. If you would, there's another piece of paper that was handed out, looks like this.
And I appreciate you giving us this.
This is the Headley portion of the Constitution. Units of local government are hereby prohibited from levying any tax not authorized by law or charter when this section is ratified, or from increasing the rate of an existing tax above the rate authorized by law or charter when this section is ratified without the approval of a majority of the qualified electors of that unit of local government voting therein.
This has already been passed as a Headley amendment, correct?
Yes. So as we go further into the bill, where it talks about raising taxes, and when we get to it, I'll point that out, but I want you to keep that in mind, is that any creation or agency that's a part of government after the Headley Amendment, regardless of what it says in the legislation, you have to comply with the Constitution. And the Constitution is very clear. Any increase in taxes, you have to have a vote.
And this was adopted in 1963.
It was actually 1978.
Okay.
And as we go on, if the constituent unit has taxing power each year, it may levy a tax upon all real personal property within the constituent unit. which may be imposed without limitation as to rate or amount to the extent necessary for the prompt payment of that part of the contract obligations as shall fall due before the following year's tax collection. The tax may be in addition to any tax which the contracting constituent unit may otherwise be authorized and to levy, and may be imposed without limit as to rate or amount. Let me go back to the Headley Amendment. Because while it says you can do that, you can't violate the Headley Amendment.
Has to be voted on.
It has to be voted on. Okay. Let's continue through, because I think this may be an area that may be somewhat confusing. To continue with the same sentence on line 14, but shall not be in excess of the rate or amount necessary to pay the contract obligation. Any contracting constituent unit at the time of its annual tax levy has on hand in cash any amount pledged to the payment of the current obligations for which the tax levy is to be made, then the annual tax levy may be reduced by that amount. For the purpose of obtaining the credit, funds may be raised by contracting constituent unit in one or more of the following methods. Service charge to users of the facility owned by the Port Authority by setting aside state collected funds dispersed to the contracting constituent unit, by special assessment upon lands benefited. Let me stop there. Again, Headley rules is that if you're going to have a special assessment, it's still determined that you need to go through the process that Headley requires, that even with a special assessment. By setting aside any of the available money, a contracting constituent unit may agree to raise all or any part of its contract obligations by one or more of the methods enumerated in Section 2, which may be available. The various powers granted in this Act to a constituent unit shall be exercised by its governing body. And again, the next section is also governed by Headley. So if a constituent unit other than a county operating under this Act elects to raise money to pay all or a portion of its share of the cost of a project by assessing the cost upon benefited lands, its governing body shall so determine by resolution fix the district therefore. The governing body shall then cause a special assessment roll to be prepared. Thereafter, the proceedings in respect of the special assessment roll and the making and collection of the special assessments on the roll shall be in accordance with the provisions of the statute or charter governing special assessments in the constituent unit. It goes on to describe how you can do this, but again, it's still governed by Headley, is that you can't just unilaterally do that. There has to be a vote. And you go through the same process as you do for any special assessment district in terms of who votes.
I have another question on this, and I know that this is existing, but I probably want to ask the guy from Detroit about this. It says here, by assessing the cost upon benefited lands.
I'm sorry.
It's okay. It says in here, by assessing the cost upon benefited lands.
Mhm.
Now, would that mean the entire county will benefit, or would that mean the area?
I'm
right
assuming this would
where
apply to a special assessment. And a perfect example would be a port terminal that wanted to make a special improvement, and you issue debt, and the Headley Amendment talks about this. But if the way to pay it off is to create a special assessment, it only applies to that property.
So,
Okay.
so nobody else would be taxed except
Right.
the
Yeah.
people or the business in that. Thank you.
And, right,
Okay.
that specific
That's what I thought. I just
property.
wanted to double check.
Right.
Thank you.
But again, you can't unilaterally do that because
I understand that what a special
it would be part of the
assessment
arrangement.
is. I just wanted to make sure that that's what it meant in this.
Okay, section 14, line 20. An authority may provide by resolution for the issuance of revenue bonds of the authority for the purpose of providing funds for paying the cost of projects or for paying the cost of an extension, enlargement, or improvement of a project then under the control of the authority. The bonds issued under this section shall mature at a time or times not exceeding 40 years after their date of issuance as the authority may provide. as with all bonding that's done in the state of Michigan by the agencies within the state that are public agencies, those bond sales have to be approved by the Department of Treasury. Is that you can't just issue bonds without going through that process. And it goes on to say revenue bonds issued under this section are subject to the Revenue Bond Act of 1933. And essentially that's the requirement to go through Treasury before it's issued. And as those of you, certainly the people of the county, have some experience of selling bonds, and it's not easy to do. There have to be investors willing to buy the bonds, and so you normally, as this bill requires, you to go through a trustee to help sell those bonds so that there's some guarantee of the repayment of them. And again, Treasury is not going to allow you to do that if there isn't money coming in. And as we get a little further along, one thing that should really be pointed out, and that is that the authority really does not have any independent way of getting money. Is that the way that they get money is either through grants or through an appropriation that's done by the constituent unit of government, or someone gives them money, or they get a grant from the state or federal Department of Transportation. So they don't really have a means of generating revenue. So for the authority to sell the bonds on their own, that just is not going to happen. Unless they have a source of revenue, which would be if you happen to have an oil well pumping down on the small piece of land that is Heritage Landing, then perhaps the authority, if you gave them the oil well, might be able to independently finance it.
You should look into that.
Okay, revenue bonds issued pursuant to this section shall not be considered to constitute a debt of this state, a political subdivision of this state, the authority, or any constituent unit, or a pledge of the faith and credit of this state, or political subdivision of this state, or of the authority or any constituent unit, that shall be payable solely from the revenues or income to be derived from the projects. So essentially, if you are investing in a project, one of the ways to finance that would be to bond and then have the revenue that's generated from the project pay for the bonds.
And that already exists?
That already exists.
Already exists.
Yes. The revenue bond shall contain on their face a statement to the effect that the bonds and attached coupons are payable solely from the revenues and are not a general obligation of the state, political subdivision of the state, the authority, or constituent unit. Neither the faith and credit nor the taxing power of the state, political subdivision of the state, the authority, or a constituent unit is pledged to the payment of the principal of or the interest on the bonds. If you're an investor looking to buy bonds that might be being sold, you look at how they're going to be paid and how you're going to get your money. And this limits in terms of where that money would be able to come from. So it would not be an obligation on the part of the county. Which will make it fairly difficult to sell bonds. It also goes on, revenue bonds issued pursuant to this act shall be secured by a trust agreement by and between the authority and a corporate trustee, which may be any trust company or bank having the powers of a trust company, within or without the state. The trust agreement may pledge or assign the rentals and other revenues of the authority, but shall not convey or mortgage part or all of a project. The trust agreement shall contain provisions for protecting and enforcing the rights and remedies of the bondholders as may be reasonable and proper, but not in violation of the law, including covenants setting forth the duties of the authority in relation to the acquisition and construction of a project, and the extension, enlargement, improvement, maintenance, operation, repair, issuance of a project, and the custody, safeguarding, application of all money may contain provisions for the employment of consulting engineers and other professionals in connection with the construction operation of a project. The trust agreement shall set forth the rights and remedies of bondholders and of the trustee, and may restrict the individual right of action by the bondholders, may contain any other provisions the authority may consider reasonable proper for the security of the bondholders. Section 21, governing bodies of the constituent units may, by majority vote, and with or without consideration, transfer or cause to be transferred to the authority, or may place in its possession and control by lease or other contract or agreement, either for a limited period or in fee, any dock, waterfront, or riparian property owned and controlled by the constituent unit. So in other words, if the county were to be the ones forming this authority, you could convey property to the Port Authority, if you so chose.
Property that we own.
Yes, but essentially, you can do that now. Although there isn't an authority, but to some other public purpose, you can certainly turn over the land. This is another subsection 1, where they're talking about transferring property. Section 1 does not apply to an owner of private property that enters into a public-private partnership with an authority unless the public-private partnership agreement specifically provides for that transfer, possession, or control of property or rights in property. So while property can be conveyed, you can't take it. I mean, the Port Authority would not be able to, say, go into one of the operators and say, we're taking your land, because they can't condemn it, and they have no authority to do that. This is a key portion because it also guarantees that you will be the ones that are keeping very close tabs, if you are the constituent unit of government. You'll be keeping close tabs on the operation of the Port Authority. The authority shall submit in writing a detailed estimate of the budget required for the business and conduct of an authority's affairs, initially for a 2-year period, and annually thereafter to the governing bodies of its constituent units and the State Transportation Department for approval. So every year, it will be up to the board, this board, to approve the budget for the Port Authority. So if they're going to go into debt, or they're going to be owning a piece of property, or that sort of thing, those would be the things that would be contained in the budget and need to be vetted through your normal budgeting process, because you would be responsible for oversight of their budget and giving approval. The same is true for the Department of Transportation. So not only would you be doing that, but so would the Department of Transportation. That way, it makes it a lot more difficult to incur debt or have other problems.
I have a question.
Yes.
I want to ask Aaron though. Aaron, will that then come before the MPO at Mazzardick?
No,
It will not, okay.
no,
Thank you.
not unless they are seeking transportation grants.
Okay,
Then that the grant or required local match would be identified in the budget of the Port Authority, which would go through your vetting process.
okay, thank you.
This portion, unfortunately, does not apply to us. The state shall provide 50% of the operating budget of any authority created before January 1st. And as John will tell you, their 50% doesn't quite measure up to 50% from the state. That it's a few years old in terms of how it's calculated. So we would not be getting money directly from the state for this by statute. On down.
Nikki?
Yes.
Why is that?
They don't have the money.
Well, because when we apply, to cut through the chase real fast, when we apply, file the articles of incorporation, the governor's office will approve it or not approve it. And if we're getting money from the state, guaranteed, given the budget situation that we have, they won't approve it. We attempted, when I was serving in the legislature in the 80s,
We meaning the
to do
state.
that.
We meaning the state, what you just said.
Excuse me, I'm sorry?
We meaning the state.
The state would not likely give the money.
Okay. You talked about the budget, and the budget that we have. You meaning the state.
Yes, Yes. It will not come out of the state budget. Back throughout the 80s, we attempted to have some input and maybe develop a port authority, and the greatest resistance to doing that, one was fairly new at the time in Wayne County, but there was not a whole lot of appetite, given what our budget was like in the 80s, to picking up half of the operating costs for what might be 2 or 3 new port authorities. So there was no ability at that time to get a whole lot of traction with trying to have a port authority. We're going down to line 8. A city or county creating or participating in an authority may appropriate for the use of the authority and include in its levy for general fund purposes amount considered proper. So it gives legal permission for you to give them money. This is also a key. However, the total amount permitted by law to be levied by a city or county for general fund purposes shall not be considered increased by the section that allows you to give the authority money. Is used in this section, operating budget means solely operation and maintenance expenses of an authority not included in the cost of a specific project and interest on loans, but excludes amounts for debt service on bonds and amounts for acquisition, construction, enlargement, improvement, or extension of port facilities. It also goes on to say that if the authority has funds in its account at the end of the year, funds shall not lapse back to this state or to its constituent units, shall be carried forward for the next fiscal year of an authority. There is one other very important piece on page 16, section 26. The purpose of making surveys, soundings, drillings, examinations, investigations as it considers necessary or convenient for the purpose of this act, an authority and its authorized agents and employees may enter upon the lands, waters, and premises in the authority, subject to permission of the property owner. So in other words, the Port Authority could not just go on one of the private operators' property and nose around or do anything without permission. So permission would have to be given from any of those property owners within the Port Authority jurisdiction before folks from the Port Authority could enter their property. It goes on to say, subject to permission, the property owner entry would not be considered a trespass if they've had permission. Also, if there's damages that are committed while someone from the Port Authority is on the property of a private operator, the Port Authority would be subject to having to make payment restitution for the damages. That's in the last portion. With that, very happy, very pleased that John was here because he's been at this much longer than probably most folks in the state. And I